Today we will be moving forward to some of the most complicated topics in practice when you get down to the litigation, especially of follow-on cases. So we will have a lot to discuss. Before I get started, we're just going to first go through as we always do, the general program for this course. For those of you who might be coming in for the first time and don't know what you have missed. Also the rules of conduct. You are invited and I really hope you do participate through the chat function, and then if needed by turning on your microphone. And the workshop is being recorded, and if you do not wish to appear, please do not turn on your camera, because one or two people always appear in the recording randomly. I'd also like to give a shout out to Valeria, who is watching us from the hospital. I've been informed, and she is recovering from surgery. All is going well, but I am very impressed that we have a student who is so committed that she's watching this course even from the hospital. So thank you for that. And I would like to begin by asking if somebody has questions concerning yesterday's session, because there was at least one question which we didn't get a chance to address. We didn't have time. So please, if there are questions that you would like to discuss concerning yesterday's session, do raise them now, either in chat or by turning on your microphone. Okay. Well, you can always bring them up later if you wish. Let's begin. Requirements of liability for an infringement of Article 101 and 102. We have already addressed this in a general way when we talked about what is governed by EU law and what is governed by national law. And today we will be going into greater details on this subject. So we have already seen that case law tells us that because the right to damages derives directly from EU law, the requisites for liability, to be entitled to compensation or to have the obligation to pay compensation, also derive from EU law. They are regulated directly and exclusively by EU law. Much in the same way, in fact, inspired on the case law that said that member states are liable for infringements of EU law, and that the conditions for that liability are foreseen in EU law as clarified on a case-by-case basis by the court. The analogy is not perfect, so some of the things that we find in the case law on member state liability just do not apply here because the nature of the practices are different. You can't compare actions of an undertaking to general and abstract legislation adopted by a member state. But to the extent that there is analogy, the court is drawing inspiration from that case law to now develop the requisites for liability for antitrust private enforcements. If you know anything about the case law for member state liability, you will also know that already foreshadows a lot of problems to come, because especially experts on civil law have been very hard on the court by pointing out that we really don't know much about how to flesh out these requisites that have been set out in the case law about member state liability, because the court just gives us these general ideas and doesn't really develop them much. To be fair, civil law also really doesn't develop them much, and it's up to doctrine to discuss what exactly is meant by all these things. And then there is profound legal uncertainty at the national level as well about what these requisites are, and it's up to academics to discuss them and for courts to inevitably disagree on them sometimes. So we will have a significant margin of legal uncertainty here, and there will be the tendency for different member states to interpret them differently based on the way that these same requisites and principles are interpreted in their own legal order, which of course is a danger, because that just because one country interprets a requisite framed in the same way in a given manner doesn't mean that this is the way that the European Court wishes us to interpret that requisite. So we will need a lot of opportunities for the court to clarify this, and on a precedent basis, we will gradually learn what the court has in mind. And I am sure the court will have many chances in the years to come to develop each and every one of these requisites. This first chapter will not deal with fault, damage, and causality, because we'll deal with those later on in sections 11 and 12. I would like to begin by addressing what does it mean to prove an unlawful behavior? What does it mean to prove an infringement of EU competition law? And of course, I'm talking here about a standalone claim, because otherwise the infringement would already be proven. We'll talk about that tomorrow. What is required of the claimant who has to prove this? And I already mentioned this briefly yesterday, but I really want to point this out today and to take you through a little hypothetical exercise, because people who are not familiar with the intricacies of competition law, they're usually oversimplistic in their assumptions of the burden that is put on claimants and of how hard it is to identify an infringement of competition law. So on this slide, you find a few hypothetical examples for us to consider, and then at the bottom, a list of things that will apply to some of the hypothetical examples. So imagine that you need to prove the existence of a secret cartel. You've been tipped off by a friend, for example. You're a manager of a company, or you're an in-house lawyer for a company, and you've been tipped off by a friend that one of your suppliers is involved in a secret cartel, and you have been paying a lot more than you should. What do you have to prove, and how do you go about proving? Well, in the case of secret cartels, this is obviously incredibly difficult, because you will need to have access to evidence that the secret cartel does exist. You could always approach it from a concerted practice approach with economic studies showing that even in the absence of actual agreement, there is no other reasonable explanation for the behavior of the companies other than the fact that they are concerting their practices, but that they're coordinating their practices somehow more than a parallel behavior, which is expectable in, for example, oligopolistic markets. But that is incredibly difficult, and the rate of success is just surely going to be very, very low going down that path. So you will need to have, first of all, you're going to need to have access to some kind of evidence, exchanges of email, recordings of meetings or notes of meetings, witness statements, something. And this is notoriously, or infamously, I should say, difficult to obtain, which is why even competition authorities who can do dawn raids, they can walk into companies and seize documents and record the contents of computers and etc. Even they find it very hard to detect, which is why they are so keen on protecting leniency programs, because they feel that without leniency programs and companies coming forward with information, they will not be able to detect most cartels. So if public authorities can't do them, how are private enforcement agents supposed to do it? But let's get past the secret part. So what would you need to prove in order to show a cartel? You're going to have to prove that there was a significant effect on the market. You're going to have to prove that there was an effect on cross-border trade. And this will usually, especially the significant effect, will usually involve some kind of market definition. You're going to, most likely the cartel is going to have a restrictive object, so that might be easier. But to be on the safe side, depending on the type of practice in question, you might need to argue also that there is a restrictive effect, and that is incredibly complicated. Anytime you ask somebody to prove that there is a restrictive effect, that is just, unless you're doing economic studies of the market and you have access to a lot of data prior, before, comparative with other products, other regions, etc., showing a restrictive effect of a certain practice on the market is incredibly difficult, if for nothing else, because you will end up with a problem also of causal link. I mean, okay, we observe certain variations of the data, but was this caused by the cartel? There is a reason why also public competition authorities don't usually have restrictive effects cases, and they tend to choose the restrictive object cases. But imagine that you can prove all of that. You still don't have an infringement because the other side might say, yeah, we did do a cartel, but this is perfectly justified for the reasons set out in Article 1013. Or maybe there's a category exemption that applies to it. I didn't put that on the list, but that's another thing that can be invoked. And it's true that you don't have the burden to prove that Article 1013 is not met. That's up to the other side to prove that it is met. But you don't know if there is an infringement. There is technically no infringement if the requisites are met. And applying Article 1013, we all should know, is very, very difficult and requires access to incredibly detailed data on the market. So very difficult for you to actually know if there is an infringement because of 1013. The same issue, by the way, is going to arise when you're talking about 102, because you don't have a paragraph 3, but you have the positive economic balance, which is set out, the test, which is set out by the case law, which ends up in the same discussion. It's basically a rule of reason. Do the positive effects outweigh the negative effects? And we just don't know if that is the case. That is always an incredibly subjective discussion. And then there is the wild card, Wouters. The Wouters case law, which has been confirmed at least twice after that, is just an endless pit of uncertainty, because you might have companies or public entities, depending on what the nature of the case is, you might have them invoke the argument that yes, this did restrict competition. Yes, this doesn't pass in Article 1013 or in the positive economic test of Article 102, but there are overriding general principles that justify this restriction, and so under the Wouters case law, this is not forbidden. This is necessary to protect public health, or the good functioning of the judiciary system, or this is important for public order, environment, whatever. And then it comes down to a subjective discussion of proportionality. So you really have to go through the details of each case. And if you put yourself in the position of the claimant or of a competition authority and go through every step that you need to do in order to be sure that there is an infringement, you're going to see how incredibly complicated it is. But let's go back to some of these examples. Imagine that you are consulted by the owner of a small coffee shop. He has a contract with a large coffee supplier, and he thinks that there is an exclusivity clause that infringes competition. In order to know if that exclusivity clause infringes competition law, some things are going to be fairly straightforward. If it's a 10-year exclusivity clause, most likely it's going to be excessive. But it's just one agreement between a small cafe holder and one manufacturer. That's manifestly de minimis. And the only way it's not de minimis is if, so the only way it does have a significant effect and is forbidden by 101 is if there is a bundle of agreements which have the exact same clause, be it of that one manufacturer or even of several manufacturers. And you're not going to know that unless you have access to the other contracts that are carried out by this coffee supplier. And realistically speaking, the lawyer of this one cafe shop is not going to have that. And if he tries to have access to that through disclosure, he might be successful, but good luck. It's certainly not going to be easy in countries with no culture of disclosure, especially in a pre-filing stage. So what are you going to do? You're going to go to court on the off chance that you might be right and the other agreements have the same clause and they cover a large market share and therefore there is a significant restriction of competition on the market? Probably not. Probably what you're going to do is you're going to complain to the competition authority and hope that they investigate the issue, right? Another example, margin squeeze. In order to prove a margin squeeze, this is debatable and it's very complicated, but usually in order to show a margin squeeze, you're going to have access to the costs of the dominant undertaking. You can also try to build an econometric model of the costs of an efficient undertaking operating on that market, but as you can see, the first is incredibly difficult. You certainly won't usually have access to that unless you have disclosure and functioning well. And the second requires a lot of investment in obtaining data on the market, which might not be available, and then on paying economists to analyze that data. Any abuse of dominance case has one fundamental challenge in the beginning, which is you have to define the market. You have to be fairly convinced that your market definition is correct and is going to be upheld by the court. And then you have to establish dominance. And sure, you have presumptions of dominance based on market share, which might be helpful to you, but you still have to be convinced that even if you have that market share, that there aren't arguments saying that despite the market share, there is no dominance. And there might be. There usually are. I'm sure the other side is going to come up with arguments to say, even if they have 60% of the market or whatever, they are not dominant. And so if you're not sure of the dominance, you're not sure that there is an abuse of dominance, and you're not sure that you have a right to damages. For predatory pricing, you're also going to have access to the costs of the undertaking. Otherwise, you have no idea if there is predatory pricing. And even then, after you have access to the costs, it is highly debatable. You're going to be unsure whether the data that you have obtained is true, whether it hasn't been manipulated in some way. Even if you have a revision of the accounts by independent auditors, that, as we've known, for example, as we know after the in so many cases involving banks, that doesn't necessarily mean that everything is on the up and up. And there are other examples and other examples that I could go through here, but basically the point that I'm trying to make is never ever underestimate how difficult it is to prove an infringement of competition law. And I would take that even one step further. Never underestimate how difficult it is to know if there is an infringement of EU competition law. And that's what the court is talking about, I think, when they say that this is an area that has to be distinguished from normal tort, because it is just so complex. There is so much legal uncertainty on so many requisites that to talk about this in normal tort ways of you just need to be aware of the behavior, that's just not reasonable. And there is a reason why the directive says that you need to be aware that the competition law was infringed. And the question going forward will be, what does that really mean? What is we've heard yesterday from Martin that this ultimately you might never know that the competition law was infringed unless you actually have a res judicata decision saying that it was, and it's consolidated in the legal order. That is a problem, but that is a problem that comes hand in hand with the nature of competition law infringements. And I'm not sure there is much of a solution around that beyond a reasonable approach to an absolute limitation period rule. So let's move on. Still within the requirements of liability, one topic which is incredibly complicated, and I will not be going into it in any detail here, is the issue of joint and several liability. This is set out in Article 11 of the Damages Directive, and if you're interested in it, please read this article in detail. But be warned, I've spoken to several PhD students who are working on this article, and no one understands exactly what these rules mean, and everyone has doubts about how this would work in practice. Because it seems fine when you're thinking about it in abstract terms, but as soon as you start applying it to hypothetical cases or to real cases, now that we have several real cases, the whole thing crumbles and shows that it's really going to be very, very difficult to apply. So the basic idea is that, let's talk about cartels because it's the easiest example. If there are several members of a cartel, and those members participated in a single and continuous infringement, all of them, this already is a problem because within the same cartel, there will be people who did not participate in a homogeneous single continuous infringement. Some of them will have participated only for a part of the time, only for some of the market, only for some of the products. And then it comes down to did the commission find that they were responsible for the single and continuous infringement, or did the commission or NCA not do that finding? There will be case law on liability. There is case law on liability for single and continuous infringements at the public enforcement level. That is already, there's consolidated case law there. And of course, applying the Skanska logic, the court will most likely say that all of those clarifications are also applicable to liability for single and continuous infringements in private enforcement. Basically, the bottom line there is if you knew about what the other guys are doing, it doesn't matter that you didn't participate in those parts of the cartel because it's a single and continuous cartel. It covers those areas you knew about it or should have known about it, and therefore you're going to be held liable for it. It's a bit of a simplification, but that's the bottom line. Still, what happens if you were only held liable for 2 of the 5 years that the cartel where the cartel took place? Does that mean that you're only going to be jointly and severally liable for the damages which occurred within those 2 years? That's probably what it means, but there are question marks there. It's really going to depend on how the decision is framed and on the circumstances of the case. But that's just the basic level, because then all sorts of other complications arise. One complication you already heard about yesterday with the Trucks Cartel. So Skanska appealed and the other ones didn't. Does that mean that you can sue the other ones? You can sue MAN or Volvo or Renault for the part of the infringement that was caused, well, the damage, part of the damage that was caused by the sales of Scania. There is no res judicata declaration of infringement as yet in relation to Scania. So is the court bound by that decision? There is certainly a decision saying that Volvo or MAN, they did this cartel, and this cartel affected all of these clients, including the ones by Scania. Even if it didn't say that, even if you could say, no, it doesn't say Scania, you could say, well, umbrella effects, it would have applied to their clients as well. So if that is the case, what happens here? How are you going to, you're going to find them jointly and severally liable, but the other case is going to be litigated for several years. And then at the end of the case, imagine Scania wins and there was no infringement in relation to Scania. Does that mean that, you know, the other cartel members had to pay compensation and now they can't exercise the right of return because there is no infringement as far as Scania is concerned? Unless, of course, they file a standalone right of return action and they prove that Scania did participate in the claim. Nothing in the cartel, nothing prevents them from doing that. The court will is not bound by the absence of a declaration of infringement, right? It's not going to create, the court is not going to say that that there was no infringement. The court is going to say that the commission did not prove that there was infringement. So these cartel members could then go to court and prove that, oh yes, there was, Scania did participate in the infringement. But this is just another level of complication, right? And procedurally, it's going to raise issues like, should you suspend the case against one because the appeal of another is still pending? So again, I'm just lifting a bit of the veil here on the number of complications that are going to arise. And then you have other complications that have to do with exceptions to joint and several liability. The main exceptions here are exceptions open for leniency beneficiaries and the exceptions open for small and medium undertakings. SMEs, small and medium enterprises. So I'm not going to go into the details of those, but basically, if you have been the beneficiary of leniency in a way so as to avoid you being too exposed to having to pay damages already for for what was effectively damage arising from the sales of other people who did not come forward and benefit from leniency, the directive says that you will not be held jointly and severally liable for the share of the others, right? Unless at the end of the discussion with the others, it is discovered that they will not be able to pay those compensations. So you are jointly and severally liable, but only subsidiarily if the other ones are unable to pay And I don't even know where to begin addressing the complications of that. I mean, what does it mean? Nobody knows exactly what does it mean they're not able to pay. We imagine that bankruptcy is going to be included there, but what about other situations? Will other situations be included in that description? And we also have problems concerning the timing of the thing. If it takes 10 years to litigate against the ones who then end up not being able to pay, you couldn't have been litigating against the other guy because he was not jointly and severally liable. He only becomes jointly and severally liable 10 years down the road when we find out that the other guys aren't able to pay. What about time bar? I mean, hasn't it become time bar? What about absolute limitation period? I mean, when you start thinking about this in practice, the enormity of it is just overwhelming. And that's why the slide is so small, because I really don't, I cannot go into much detail about this. It is, without a doubt, of all the rules in the directive, the one where your mind just twirls around the most when you start thinking about the practical implications of these rules. Are there questions before I move on to the issue of fault? Are there questions that anybody would like to raise? So Filippo asks, do you think it's fair to say that because of the many limitations in discovery, even after the damages directive, private litigation is still subsidiary to public enforcement? Well, we will be talking about, I think this will become a little more obvious tomorrow when we talk about access, but I don't think that it's fair to say that private enforcement is subsidiary to public enforcement, because statistics from the past before the directive shows us that it never was. And so it will continue not to be. I believe that the vast majority of cases, if you treat each infringement as one case, so if you would count the 10,000 cases of the Trucks Cartel as one case, as one infringement, I believe that the vast majority of infringements will still be standalone. And so I don't think it's, in that sense, I don't think private is subsidiary to public. But of course, when you're talking about secret cartels, of course it will be. Of course you're not going to have private enforcement starting independently from public enforcement. That being said, it is probable that it will be complementary in the sense that private enforcement actions will go beyond the scope of the public enforcement decisions, even in the case of secret cartels. They will claim that the infringement had started before, because once the, or lasted after, or had other components, again, because NCAs tend to be cautious, Commission tends to be cautious, they will go for the low-lying evidential fruit. If it's difficult to prove something, they might not even try, because why bother? The impact won't be much in the end. So the private individuals will have an entirely different economic incentive to go after those cases. And so, yes, in secret cartels, it will be subsidiary to public enforcement, but there will always also be a tendency to go beyond that. Alexandra asked a while ago if, because the course is being recorded, will it be made available later this week? Not later this week, but certainly next week, we will be making this course available online. So you will be able to come back to it and to revise anything, especially for the students who are preparing papers for evaluation. This might be helpful. You will be able to revise things that I've gone over, and I know that I'm speaking very fast, so I hope that that will be useful to you. I haven't received any other questions, so I'm going to move on. Okay, let's talk about fault. If you look at the legal orders of most member states, you will find, and this is certainly the case in Portugal, under our civil code's general tort rules, you will find that not only do you have to prove the existence of an unlawful act, an infringement, not only do you have to prove damage and causality, the claimant also has to demonstrate fault, right? The defendant will not be liable unless the claimant can establish fault. And this fault obviously can be intent, but it's depends on the country, but it's not always any type of negligence. Sometimes it's gross negligence. It's, you know, if it's a light kind of negligence, the defendant will not be held liable. So that's the situation at national level. what I want to address now, and we've already looked at this very briefly in the previous lesson, is fault a requirement of liability for an infringement of Article 101 or of Article 102? The answer is yes and no. I would like to make clear that everything that I'm about to say is my interpretation based on the case law, but the issue has not yet been expressly tackled. Okay, so this is, I'm going to give you some sources, but this is not yet a matter that we can say to have been settled in the case law. So why do I say yes and no? First issue, the requirements of liability, as we have seen, have been settled in EU case law. They are governed directly by EU law, and the court has never mentioned fault. Right? Fault is just not among them. It lists three requisites: infringement, damage, causality. That's it. Right? And there you have the basic quotes, for example, from Manfredi, but you find this basic quote in all the big damages referrals. No, any individual can claim compensation for the harm suffered where there is a causal relationship between that harm and an agreement or practice prohibited under Article 101 or 102 of the treaty. So those are the three requisites. There is no mention of fault, and there is a reason for that, which we will get to. The second thing is that, as we've seen in Skanska, the court will interpret competition law homogeneously, independently of whether you're applying it in public enforcement or you're applying it in private enforcement. Why am I pointing this out? Because in public enforcement case law, we already know how the court treats the requirement of fault, right? So what I'm arguing is that the requirements of an infringement of Article 101 and 102 will be exactly the same. When you're trying to prove an infringement of 101 or 102, you're going to have to prove the exact same requirements in public enforcement and in private enforcement. And the requirement of fault is a part of the assessment of an infringement of EU antitrust law. It's there clearly set out in the public enforcement case law that you need. I mean, I'm simplifying this a little bit, but the assessment of whether there was intent or some negligence on behalf of the undertaking has to be demonstrated in public enforcement in order to find a company liable for an infringement of antitrust. And so we can extrapolate to say that it doesn't matter if you're applying fines or if you're finding the company liable under in a civil claim. When you identify the infringement, you will need to identify intent or negligence on behalf of that undertaking. This means, by the way, this means that every case, all the case law concerning how you flesh out this requirement, what level of negligence, for example, is required, that case law from the public enforcement sector will also be relevant for the private enforcement application of antitrust. Now, an important conclusion to derive from this is that when you have a follow-on claim, right, what you have is a decision where you already have a declaration that 101 and 102 was infringed. And that declaration necessarily included an assessment of fault, a declaration that there was fault. So you have there an example from the Trucks Cartel, a paragraph from the decision number 1 of the Trucks Cartel, where the commission says, in this case, based on the facts, blah, blah, the commission considers that the infringement was committed intentionally. So you're going to find necessarily in any decision that finds an infringement a paragraph that says something like this, or it says that it was at least committed negligently. There might be more to back it up, but you're going to find that conclusion. And this is incredibly important because it means that the binding effect of the European Commission decision is binding effect in what concerns the existence of the infringement is also applicable to the existence of fault, because fault is subsumed in the identification of the infringement. And there is already an interesting stand on this by the Competition Appeal Tribunal, which always tends to take the lead in such discussions. Very, very interesting judgment there, also arising from the Trucks Cartel case, Royal Mail versus DAF, very recent judgment. And I recommend, if you're interested in this issue, if you're interested in the binding effect of decisions, please read this judgment. It is fascinating, the approach that the justice here in this case did. But basically it confirms what I've just set out, that specifically in what concerns fault, but also in many other things, if it's an essential component without which the operative part of the decision would not survive, you cannot have a declaration of an infringement without this component. If it's an essential component of that finding of infringement, then it is covered by the binding effect of the decision. Now, Advocate General Cocotte has argued that requiring claimants to show an additional element of fault would make it excessively difficult to exercise the right to damages, meaning it would be an infringement of the principle of effectiveness. So that is another way for how we can get to this same result of saying, not only is it not set out in the case law, but if you were to do so, it would be a violation of the principle of effectiveness. But of course, you have to take that position within the context that you have already demonstrated infringement. When you were proving the infringement, you have already demonstrated fault. So I think that what we should understand that Advocate General was suggesting is that you cannot be more demanding in what concerns fault than you are already demanding when you prove the existence of the infringement. Another very important note in practice: fault is ascribed to the undertaking, to the economic unit. And this is going to be counterintuitive. It's going to be very problematic for many people with civil law training. But all discussions of liability within the lex specialis that is competition law, they are based on economic units. They're not based on legal personalities. And there is no point saying, the general rules say you cannot ascribe liability to economic units, you have to ascribe them to legal personality. That argument completely refutes the possibility of a lex specialis. This is a lex specialis. It's hierarchically identical to the rules that people usually invoke. So unless they can come up with a fundamental right or a constitutional obstacle to ascribing liability to the economic unit, and including ascribing fault to the economic unit, that argument really won't be successful, in my view. I hope it won't be successful. So what are the practical consequences of everything that I've been going over? The first one is that if you're in a follow-on claim, you have in your hand a decision of the competition authority, and if that decision has already become final, you do not have to prove fault, right? You go before the court, you invoke that there was an infringement, you point out the paragraph where there was a finding of fault. I mean, obviously there had to have been, otherwise there couldn't have been a conclusion of an infringement, and you no longer have to prove fault. This is important because, for example, in the Trucks Cartel and in other cases, the defendants are claiming, there was no proof of fault in the claim form. There was nothing about fault. It doesn't have to be. It doesn't have to be because there was already a finding of infringement, and fault is not an autonomous requisite. If you are having a standalone claim, you do have to prove fault. However, you prove the fault when you are proving the existence of an infringement, and there is no more demanding requirement that can be imposed above that, above and beyond that. You're going to apply the relatively low standard of EU case law developed for public enforcement, but applicable to private enforcement, the relatively low standard concerning what is negligence, for example, what kind of negligence makes you liable for an antitrust infringement. I say that there is a low threshold. There's a very, very low threshold for fault in infringement of Articles 101 and 102, and I've given you there an example. There are many, many cases that talk about this, but I've given you an example of one case where the court discusses the issue. Right? It says that the case law establishes that the condition is satisfied where the undertaking concerned, undertaking, not legal person, undertaking, so economic unit, cannot be unaware of the anti-competitive nature of the conduct, whether or not it is aware that it is infringing competition rules. Therefore, even if the undertaking wrongly thought that what it was doing was fine under the law, this cannot have the effect of exempting it from the imposition of a fine, as long as it couldn't be unaware of the anti-competitive nature. So if I am to try to break that down into simpler words, what I would say is that an agent on the market knows very well when it is doing something that is restrictive of competition, either by object or by effect. It knows that, right? In fact, almost everything we do on the market is aimed at restricting competition. I sign an agreement to supply somebody. I'm preventing other people from supplying that, from supplying that same person in that same amount, because it's no longer required. So here, when we talk about restriction of competition, of course, within a rule of reason, right? A restriction of competition that we know intuitively that is not a norm. It doesn't occur necessarily in the normal course of business. So if a company knows that it is restricting competition, it doesn't matter that it didn't know that it was illegal. And this is a general principle of law. There's nothing new here. What matters is the action. You can't invoke ignorance of the law in order to get away with paying a sanction or paying compensation. This is basic. And of course, it gets very complicated in competition law, because competition law is so complex, and many companies, sometimes in good faith, they might think that they're complying with competition law, and then the court says, no, you weren't. But so be it. That happens in criminal law as well. So it happens in every branch of the law. So that's just unavoidable. Let me go back to some questions that in the meantime have been posed. Some people are asking about paper topic questions, so please do address those questions to me by email, so I can answer them after the session. Alexandru asks, in case of indirect buyers affected by a cartel, fault is assessed in respect to the general anti-competitive conduct, or would you need to prove a specific fault towards those buyers? Again, you're missing the point, Alexandru. It's not, the fault is for the infringement, so you don't have to, you're discussing causality and not fault. The fault is in the infringement, and you're coming up with the issues of indirect buyers and passing on along the vertical chain. That's an issue of causality, and we will be talking about that later on. So fault plays no role in that assessment. Well, actually, that's not entirely fair what I'm saying, Alexander, because it does play a role. And I think we're going to see, it does play somewhat of a role, and I think we're going to see, no, it doesn't play a role. It's still causality. We're going to see in one of the causality slides what the causality test is, and some people might say that includes an element of fault, but I don't think it does. We'll get back to that. Grigoris asks, when Cocotte says that a fault requirement would violate effectiveness, and a contrario, that it is not an autonomous EU concept, does that imply that it is not a constitutive condition of the right in the sense of Skanska? No. So what Advocate General Cocotte was actually, along with Advocate General Val, the creator of the doctrine that for the first time, very clearly made the difference between constitutive conditions and what is governed by effectiveness. And you make a great point in your question. I think that we're all still struggling with organizing our ideas about this new reality. But the bottom line here would have to be that I think we would have to interpret her statement as it would violate the principle of effectiveness, but that doesn't mean that it's governed by national law. So for example, if you're applying Portuguese law to this, our transposition makes the principle of effectiveness binding regardless, even if you're just applying national law. But really in this situation, I think I would go back to what Advocate General Val said in his opinion about this issue, where there is also an idea of effectiveness which is being applied at the EU level. When the court is building the requisites of EU law for this, it is also coming up with effectiveness. And I think Niels Wahl referred to it as full effectiveness and tried to differentiate it from a more mitigated test of effectiveness that would happen at the national level. But that, of course, was just his opinion. Petra asks, is constructive knowledge enough, or do I need actual knowledge? I don't know, Petra. That depends on what you understand by constructive knowledge and exactly, I guess you mean of the infringement. Would you like to explain what you mean by constructive knowledge, Petra?
Do you hear me?
Yeah.
Okay, constructive knowledge means that I should have known, and but I didn't know.
Well, for sure. Well, if that's your definition, then for sure. If you should have known, then absolutely that would fall within the test set out in public enforcement case law for what is sufficient fault in the finding of an infringement. Yeah.
Thank you.
Filippo asks, settlements are carefully negotiated to prevent or to mask declarations of intent and fault. Absolutely right. And in fact, this is one of the most shocking aspects for somebody looking at it from the claimant's perspective. It's understandable why competition authorities are doing so many settlements, but it's shocking the extent to which they're negotiating sometimes the content of the decisions. And you're right, they do that to prevent and mask these declarations. But other things, they do that to prevent and mask more than the fault, because there you really need to have a declaration of fault. They do it to mask the details of the infringement itself. And that's where it really gets bizarre. Does this mean claimants have to prove fault themselves? Do they believe courts are at ease to still find fault? So again, Filippo, you need to keep in mind, this is not possible. You cannot have a finding of infringement without fault, right? So you could have a decision that is written so badly that it doesn't include any paragraph with a finding of fault. And yet, logically, under competition law, if there was a finding of an infringement, and if that finding of infringement became res judicata, it necessarily implies that there was fault. Otherwise, you couldn't have an infringement, right? So the hypothetical problem that you're posing wouldn't actually occur, especially because you're talking about settlements. And in settlements, there is a confession. Usually, there is a confession that you did carry out the infringement, and therefore, you met all the requisites of the infringement, and one of the requisites is fault. Right. Sander says, in recital 11 of the directive, it is stated that it is possible within the limits of the case law of the ECJ for member states to provide other conditions for compensation under national law, such as imputability, adequacy, or culpability. To me, this recital seems a bit strange if we say that fault is a condition for liability governed by EU law and not by national law. Let me go to these, this recital, just to make sure what we're talking about. So the first thing, well, I'm going to try to read as I speak, but the first thing I'm going to say about this is that there are discrepancies between the recitals of the directive and the case law of the court, especially the later case law of the court that follow the directive. And the reason for that is very simple. The directive was first written by the European Commission, who is a friend to private enforcement only up to a point, and it is not itself a private enforcement claimant. Or actually, it did turn out to be in one case, but that was a different service. That was the legal service. This was written by the DG Comp, and DG Comp doesn't have experience and doesn't usually think in the way that a claimant thinks about it. So they were not foreseen when they wrote the directive that EU law would govern all the requisites of civil liability. And the member states, acting as legislator in the council, certainly didn't see it. And so you find in the recitals things that will not sit very well with some of the later case law. Right, so there, yes, you do have that. Issue. In concerning this paragraph 11, So, for example, right at the beginning, you have the restatement of Manfredi and other case law. So you have the affirmation that these requisites are governed by case law, by EU case law. And then you say all national rules governing the exercise of right to compensation for harm resulting from an infringement, including those concerning aspects not dealt with in this directive, such as the notion of causality, must observe the principle of effectiveness and equivalence. Right, and this is where we get into trouble, because it's suggesting that they're governed by national rules, and they're not. They are governed by EU law, and so there really isn't room for the application of national rules. So this is just, I'm sure if I keep going through the paragraph and others, we're going to find the exact same problem. Just keep in mind, it's a historical succession thing. It's like asking, why would they, the comparison is not fair, but it's like asking, why would a EU legislation preceding the creation of direct effect not be written in a way that makes it sound like there is no direct effect? This directive precedes the case law of the court that clarified that even though it was expectable from Courage and Manfredi, right? But this directive precedes the full clarification that all the requisites of liability in the case of infringements of 101 and 102 are regulated directly by EU law. That only really becomes absolutely clear with Skanska, right? That's when we know that. So that's years down the road. Petra asks, under Czech civil law, fault has to cover also the damage and causality. Does it mean that this does not apply when EU competition law is infringed and I am claiming for damages? No, I mean, I don't know what you mean by civil law fault has to cover damage and causality. You mean that you have to prove fault in causing the damage and the quantum of the damage. I guess this is probably what you mean. So we're going to see, when we talk about the damage, we're going to see something that I think will answer your question, and it boils down to the criteria. This is why I hesitated a while ago when I said yes, no to does fault to come into play there, because you're going to see that there is a reasonable expectability thing, which philosophically you're discussing basically the same thing, but it's not. Some academics might say that that's fault. I don't want to get into that discussion, but what matters is the underlying content of what you need to prove. So we're going to be going back to that discussion a little bit later. Okay, let's move on to damages and causality. The reason I put these two together is that I am not a civil law expert, and I've always found it incredibly difficult to differentiate the two. I understand the abstract theoretical differentiation, but whenever we try to discuss this in a specific case, it just becomes very difficult to distinguish discussions of damages from discussions of causality, and it's just much more comfortable to put them hand in hand. That being said, of course, there is a difference between the two, but I don't think the difference is necessary to discuss for the purposes of moving forward. So the basic idea here, as we've seen before, is that the quantum of the damages that somebody is entitled to or that somebody has the obligation to pay, and the causality test, so how close must the link between the damage and the practice be, both of these issues are governed directly and exclusively by EU law. Which EU law? Articles 101 and 102, plus the general principles of EU law as clarified by the court. Okay? And then in a case-by-case assessment, as the precedents keep piling up, we will know more and more about this. Let's start by discussing the temporal succession of rules. And when I'm talking about the temporal succession of rules, I am talking about, of course, the applicability of the new regime, the regime that was set out by the directive and implemented, transposed international legislation by each member state. That's the new regime. And remember, we talked already about the rules, Article 22 of the directive, etc. So you already know a little bit about these discussions. Quantum and causality tests are clearly a substantive issue. And there, therefore, you fall under the prohibition of retroactivity. So they can have no retroactive effect. But just like we saw in the previous discussion about limitation periods, that is by far not the end of the discussion. And to understand that, let's look at the example of the Trucks Cartel. So if you have all the actions generally, I think I can say all the actions, but at least the vast majority of the actions were filed after the transposition in the respective member states. So the new regime would be, sorry, this is not applicable. The new regime would not be applicable to these issues, right? That being said, you know, even if you don't apply the new regime, there's going to be little practical impact because not just because there are few provisions on the quantum that you're entitled to, and on the causality test, there's very little that you take from this. The big issue are the presumptions that we're going to talk about, but also because there are case law requirements that would already apply before the damages directive that might lead us very much to the same results, certainly in what concerns the quantum of damages and the causality, maybe not in what concerns the presumptions. So the presumptions are really going to be the big discussion when it comes to temporal succession of rules issues. Different, Carlos says applicable or not. No, it's not applicable. So because it's a substantive issue, the new regime would in principle not be applicable. But I'm saying in principle because we're going to have to clarify what does retroactivity mean. And so I'm going to get back to that when we talk about the presumptions. So if you, but just to be clear, if you're saying about how much damage you are entitled to, then that would be governed by the rules in force at the time of the facts, and not by the rules in force at the time of the filing of the claim or when the question is being decided by the court. Differently from the methodologies that we use to quantify differently from the substantive issues, the methodologies that we use to quantify and apply the causality test, they are procedural. Remember, we saw this difference when we talked about what is governed by EU law, what is governed by national law. So how much you're entitled to is substantive, but how you go about, from an evidentiary perspective, from a procedural perspective, how you go about determining that quantum, that is procedural. And therefore, any rule that has that nature, that regulates that kind of issue, will be immediately applicable and must have effects for the future. That will be true even in pending cases, as long as the stage at which the case is before the national court still allows reasonably for the immediate application of the new rule. And these procedural issues of how you go about quantifying, the methodology for applying the causality test, these are governed by national law, subject to EU limits. So a refusal to apply new rules of quantification to pending action, where old rules make it too difficult to quantify the damages, would, in my view, infringe the principle of effectiveness. And sometimes this limit is already imposed by prior EU law, but as I have said, this is going to be arguable when we're talking about the presumptions. Valeria is asking if the territorial limits of claims for breach of competition law will be discussed. No, I'm not going to go into the territorial scope of competition law because that is a general issue that doesn't really is not really specific to private enforcement in any way. This also applies, everything that I've said here also applies to the new causality presumptions. And causality presumptions are, very difficult to address from a succession of laws point of view. On the one hand, they are procedural provisions which should be applicable to actions filed after the transposition deadline. And the member state law should be interpreted, if possible, in a way that achieves this result, right? But that's my view, and this is a highly controversial issue. If you look at the opinion of Advocate General Cocotte in Cogeco, there is just like this superficial reference to the fact that evidentiary presumptions are substantive rules. There's no, it's just saying that in passing. There's no justification for it, no reference to case law, nothing. Now, of course, we know that under German law, evidentiary presumptions are treated as substantive law. That is also true in Portugal, where the majority of jurisprudence and doctrine seem to say that evidentiary presumptions are substantive rules. And the legislator in Portugal went so far as to write that down in our rule of succession of laws. So in the transposition rule of succession of laws, it specifically says, substantive rules are not cannot be applied retroactively, and evidentiary presumptions in this law are substantive rules. That might be an infringement of the damages directive. And any country that treats evidentiary presumptions as a substantive rule might be infringing the damages directive if the case law considers that a evidentiary presumption is a procedural matter and therefore falls under number 2 of Article 22, right, of the directive. This is an important discussion because it is not obvious that you can arrive at the same result, that you can arrive at an obligation of evidentiary presumption if you only apply the principle of effectiveness, meaning if you're applying the law prior to the damages directive. So in my view, are the new presumptions applicable to the actions in the Trucks Cartel, just so we can anchor our thought on a specific example? I think yes. I think because they're procedural actions, they're procedural provisions, the actions are filed after the transposition, and therefore the presumptions apply immediately for the future. And when people file these claims and when people defended against these claims, they already knew about these rules, they were already in force, and so they will be applicable. And by the way, you can use the same line of thinking to arrive at the same conclusion subsidiarily, even if you qualify presumptions as substantive rules. Because again, we go to the same problem that we looked at in limitation periods. Just because it says no retroactivity doesn't mean you know exactly what that means. Again, there are different types of retroactivity, and if the rule was already in force when somebody prepared the claim, if the rule was already in force when somebody defended against the claim, where is the retroactive effect that we're guarding against, right? To protect the expectations of people. They knew exactly what to expect when the action started. It's not like they were surprised by the application of these presumptions, and they had full rights and opportunities to use these presumptions or to defend against these presumptions, right? And I am, a firm believer of taking step backs and thinking about the teleology of rules. I don't think that a defendant can invoke any kind of interest which is worthy of our protection against the imposition of presumptions which were not in force at the time of the infringement. They were in force at the time when the action was filed, but they weren't in force at the time of the infringement. Why should we be protecting that? They wouldn't have done the infringement if the presumption was already in force at the time. Why? Because they realized it would have been much easier to pay compensation, to be forced to pay compensation, so they wouldn't have done the infringement. Is this really worthy of our protection? And if we go down that path, doesn't that mean that we are freezing our procedural law? Well, if you consider this procedural law, but anyway, we're freezing our rules on evidence for 10, 20 years in the future, right? Because we know if we do that option, and in long-lasting cartels and long-lasting practices, and then the public enforcement investigation takes long, and then the private enforcement investigation takes long, you're going to be applying evidentiary rules from 20 years ago, 30 years ago, when society's thinking about the reasonability of these evidentiary rules has already moved forward. Society and the law has already considered these evidentiary rules are unfair. And that's why we've changed them, that they don't guarantee the effectiveness. So one way or another, I think, you're going to have to find a solution that allows you to apply these presumptions. be it because you find that as a matter of law, in terms of succession of rules in time, they are applicable, or because not to apply them would infringe the principle of effectiveness. But you're going to have to arrive at that conclusion. And again, there is a reason why these presumptions were put in the directive by the legislator. And that reason is that the legislator thought that in the absence of these presumptions, the exercise of the right to damages would be made excessively difficult or even impossible. And that's what I mean when I say, don't forget that the presumptions could already be imposed by EU law before the damages directive. So if that is the case, there is no actual issue of succession of laws in time, because it was already imposed before. It's just that now it's written down in the directive. Filippo says, so before I move ahead, Filippo says, this is very interesting. I'm still puzzled by the distinction on what is ruled by EU and member state law and damages calculations. Well, yeah, go ahead, Filippo. You want to take the floor?
Yeah, thanks a lot. This is very interesting. So imagine a situation where, so the directive says that you're entitled to full compensation, right? So imagine this includes lost profits. But from what I understand, the way that you calculate lost profits is up to each member state. So that, can there be a situation where a person that was damaged by the Trucks Cartel file an action in Portugal and gets 10 in lost profits, and then files a different action in the Netherlands, someone else, then gets 12 in lost profits because member states calculate differently? And then would this be a violation of the damages directive, or would this be okay under the damages? That's what's really puzzling me to understand, like, because the rules on evidence and calculation are going to be different between member states.
Yeah. So I think that first of all, I would just adapt your question, and I wouldn't so much focus on loss of profit. I would rather talk about surcharge, because most Trucks Cartel litigation is not really focusing on loss of profit. It's the surcharge that's the debate. But it doesn't change your question. If you look at that, I think that the bottom line is that of course there are going to be different decisions. Of course there are. And that has nothing, of course there are going to be different conclusions on quantum of damages. And that has nothing to do with it doesn't necessarily have to do with differences between national laws. It has to do with differences between people. Both the lawyers who have prepared the case and come up with evidence, and some are good, some are bad, some know what they're doing, some don't, some come up with economist reports, some don't. That's one problem. And the other problem is the judges. The judges interpret law differently. Their own law they interpret differently. So if you look at the outcomes of the cases in Spain, you have no damages, 5% surcharge, 21% surcharge, and everything in between. For fundamentally the same facts on the same market, applying the same laws, including the same procedural rules. So of course you're going to have these discrepancies. But your question is more specifically about the extent to which these discrepancies might be prohibited by EU law. I think that we can have a theoretical discussion, but that is not very useful. The theoretical issue is that as long as the discrepancy is based on a different interpretation of what one is entitled to, that would be an infringement of EU law. But that's not going to be the case in the vast majority of situations. The vast majority of situations, the discrepancy will be based on assessment of evidence and facts and conclusions of facts. And there, I think discrepancies are inevitable. That being said, maybe moving forward, and we're going to talk about one of these issues later, maybe moving forward, there will be some developments in case law which will make it easier to identify a discrepancy that violates EU law. And one of these things that I'm thinking about is the presumption of damages, and specifically a presumption of a certain quantum of damages. But I'll get back to that later. So let's turn to quantification. The basic principle in EU law in this regard is very familiar, I think, should be very familiar to all of us from our own national law. That basic principle is that you need to be placed, the injured person needs to be placed in the position that they would have found themselves in had the infringement not occurred, the position that they would have found themselves in at the time the court is deciding the matter, right? And in fact, at the time where the compensation is fully paid. So that's the expression of the principle of full compensation. You have already prepared, you can find already prepared by the European Commission 2 guidelines on quantification. The first one is, and the directive requires the Commission to prepare guidelines. The first one is a general guide on quantification, which basically looks into the different economic methods that you can use, depending on the characteristics of the case, depending on the type of evidence and data that you have available, the different methods you can use to quantify damages. And I'm not going to go into these methods because this is the playing field of our friends, the economists. But I'm sure you've all heard of some of these ways. You can compare the prices to other markets. You can compare the prices to other times. You can compare the prices to other countries. You can look at costs and try to determine what would be a reasonable profit margin. And then there are many ways that you can identify a surcharge. When it comes to loss of profit, it becomes even more complicated. Of course, you have to make estimates about market shares that would have been achieved or maintained. So the discussions here, of course, are endless. And so aside from these guidelines on damages quantification, which already go back to 2013, more recently the Commission adopted a communication also on passing on how national courts might address, from an economic perspective, the identification of passing on of damages along a vertical chain. So you have those 2 very useful documents that have been already put forward as soft law, non-binding indications by the European Commission. And some of the transpositions of the directive in some member states expressly refer to these guidelines and either require or at least recommend to courts that they take into account these guidelines when they are quantifying damages. How does one quantify damages? Okay, I really can't go into the intricacies of that right now, but I will point out that there is one discussion here which is going to be very difficult for some countries, and that is the discussion of how do you distribute the evidentiary burden. In Portugal, for example, traditionally there is a very rigid approach to the distribution of the burden. The burden is on one side or the burden is on the other, and that's it. I'm simplifying terribly, okay, but in other countries it's not so problematic because there is a greater openness to a dynamic distribution of the evidentiary burden. But I think that if you are to comply with effectiveness, a dynamic distribution of the burden is inevitable. What that means in practice is that sometimes, for some aspects of what you need in order to prove how much you were damaged, some of the data is going to be primarily in the hands of, for example, the cartel members, right? They're the ones who have most of the information about the market. If you're a small company, you don't really know much about the market of trucks. And so there's a gigantic asymmetry of information. And in that situation, the principle of effectiveness would require the court to say, well, these guys have done, the claimant has done the best it could, reasonably speaking, to meet its burden of proof. And if I am not to deprive them, if they're not to deprive their right to damages from all its effectiveness, I now have to kind of shift the burden of proof to the other side to show me that this is not the case, that this reasonable case that they've come up with on the basis of what they could have, what they did have access to, is just not reasonable. And then after the other side, if the other side comes forward with evidence to say, well, that's just not the case, then the burden can shift back to the other side to say, no, it is the case. In the meantime, they've had access to more facts, more documents from the other side, and so there needs to be a more flexible approach to this kind of discussion, because of the complexity of quantifying damages in antitrust cases. If we're rigid in our approach to this, what that means is that people will not be able to prove damages. Now, there is another solution for this problem down the road, which is the estimation of And I'll get back to that later. So even if you don't go down the dynamic distribution of evidence, you can still prevent the frustration of the effectiveness of the right to damages by estimating the damages later on. Another issue here is, are economists indispensable, and can they be indispensable? Now, there is a serious problem in the way that we think about antitrust private enforcement, in the way we think about law generally, and that is that precedents tend to be formed by the cases that do go to court, and the cases that do go to court in antitrust private enforcement are large cases. This is not true for all law. In fact, some of the most important precedents in EU case law have come down from really tiny disputes about tiny little things, and they were the pretext for the court to clarify fundamental aspects of EU law. But that's not, that might happen when somebody is challenging a tiny amount of a customs duty that was charged to it in the 60s, and even though the amount is tiny, it's a simple thing, and they invoke EU law, and it goes to the court, and the court says direct effect, and that's great. But that just doesn't happen in antitrust private enforcement. In antitrust private enforcement, damages actions are not filed for small amounts, right? You need, and this has a lot to do with the specificities of each legal order. And by the way, how much does it cost to litigate, and your chances of recovering those costs are one of the most important factors that is going to deprive the right to damages of its effectiveness. This is a parenthesis that I'm opening now. For example, in Portugal, there is no loser pays principle. There is for the court costs, but not for the other side's costs. So even if you, in order to win a case, you have to pay your lawyers, you have to pay your economists, usually, right? And at the end, you have no hope of recovering those costs, none. You will get maybe 1,000 euros back or whatever. It depends on the amount of the value of the claim, but you're going to get back a very small amount of damages. In principle, if the general rules of Portuguese costs, court costs are applied, and that's really complicated. Keep that in mind in this discussion. If you need to hire economists in order to be successful in the quantification of damages, especially in countries where this is dissuasive enough if you have to pay the economists and only at the end, in case you're successful, taking the risk. In case you're successful, you'll get the costs back. That's dissuasive enough. But imagine in countries such as Portugal, where you have no hope of recovering those costs, right? Speaking as somebody who has hired economists, we're talking about investments in the order of tens of thousands, if not hundreds of thousands of euros just for the economists plus the lawyers. What this means is very quickly you'll reach a situation, depending on how you apply national rules, very quickly you'll reach a situation where private enforcement is only for the rich. And that's just not acceptable. So there have to be the courts, when deciding on, and now we're talking specifically about quantification, but we could be talking about other things. When courts look at the burden that they're imposing on a claimant, they have to take into account what costs are associated to that burden, and are those costs reasonable considering the potential benefit of that specific case. And I think that, if I'm not mistaken, there is a great solution for this in Swedish law, where they specifically say that the courts have to take into account the proportionality of the costs over the potential benefit, and they cannot impose burdens, evidentiary burdens, for example, hiring economists, when the cost of that would be completely disproportionate to the claim that they are putting forward, and especially when they wouldn't recover those costs at the end of the case, right? Even if they recover those costs, I would point that out, the dissuasive effect of the risk of losing the case and having to have, in the meantime, having paid 1 million euros to lawyers and economists, that dissuasion might be enough to keep people from going to court and exercising their rights. So there are huge policy discussions that have to be had here on a macro level. Legislators need to think about this and think we don't need to protect large companies. Large companies are going to go to court. They have their means. That's fine. But small and medium undertaking, consumers, yeah, there is a problem here. And if the legislator doesn't solve it, individual judges will have to solve it, because otherwise there will be infringing the principle of effectiveness, and meaning that small claimants can't go to court and be successful. But then let me go over this this estimation of damages issue. So the directive requires you to do something that most of national laws already said, which is that if the claimant has done everything it could, or it's done everything that was reasonably demandable of it to prove how much damage it suffered, and still the evidence doesn't allow you to precisely quantify that damage, if the court finds that this indeed is the case, then it must estimate those damages. It must use the evidence that it has to do an approximate estimation of the damages. Bottom line, the court cannot refuse to pay compensation or to order the payment of compensation on the grounds that the damage was not precisely quantified, that the defendant did not meet its burden of proof to precisely quantify the damages, if the claimant did all that was reasonably required to quantify those damages. And this is fundamental, because in the vast majority of antitrust private enforcement cases, it will not be possible to arrive at a precise identification of the damage. For nothing else, because even if you have economists, it's always going to come down to the claimant's economist saying we had 1 million damages, and the defendant's economist saying you had 0 damages. And these are experts, and they're both applying science, and both positions, at least theoretically, are defensible. And so the court, which almost never includes economists, the court is a non-expert, and it can turn to an expert economist. But the expert economist will also probably arrive at the conclusion that we don't really know. There are good arguments on both sides. There is uncertainty. That's going to be the bottom line conclusion. And the court cannot say there is uncertainty, therefore I'm not going to order damages. No, there is uncertainty, but I know that there has been some damage. It's been reasonably proven that there has been some damage. I just don't know exactly how much it is, so I'm going to have to estimate that. And we've seen this already in the Trucks Cartel in Spain. In the Trucks Cartel, the ones that have given damages, you've seen, on the one hand, there has been a string of cases prosecuted, especially promoted especially by one law firm, where the courts have been saying, yeah, this economist report that they put forward, this is persuasive. We like it. This is enough. And they've said, the economist report of the claimant says it's 20%, 21%, something. We like that. We've persuaded. And several judgments in several courts have given 20% on that basis. But then many other cases have said, yeah, we're convinced that they're damages, but we just don't know exactly how many. We're not persuaded of the precise amount. We have to estimate. And then you get estimates of 5, 10%. It varies. Each court will estimate it differently based on its own criteria. The Article 17.3 of the directive. I'm sorry. I've turned on the chat because I needed to see. Okay, there are no further questions so far. Article 17.3 of the directive has a particularly little complicated provision, which I think I want to go through it quickly because I think it's been overestimated, but it did bring up a lot of discussions during all the transpositions, I think. It says that the national competition authorities should assist the national courts in quantifying the damages in private enforcement claims if the court requests the assistance of the national competition authority. And then the directive quickly adds where that national competition authority considers such assistance to be appropriate. This is such a bizarre provision for several reasons. First of all, why is a court asking the National Competition Authority for assistance on quantification of damages in the first place? That's just weird. There are some decisions that quantify damages. For example, in Portugal, we've had a recent decision against the energy incumbent where the competition authority fined it for abuse of dominant position and calculated exactly how much this cost consumers. So you have a quantification of damages there. But then it's done, you know, and if it's done, you don't need to ask the competition authority for assistance. They already have, just use the decision. If it's not in the decision, why are you asking the competition authority to do something it hasn't done? That's just giving it a lot of work, and competition authorities are busy and they have more to do than discussing quantum in private enforcement cases. If they want to, that's one thing. But for a court to request the assistance, there is an argument to be made that in small countries, antitrust economists will, you know, be found mostly at the competition authority, and it might be difficult to find some other economist that is free, that speaks the language of the court, and knows a little bit about this. And then you might need to ask the competition authority for assistance of one of its economists. Okay, maybe, but that's more an issue of designating an expert witness rather than asking the authority institutionally for its assistance. So that's one of the reasons why this is weird. Another reason why this is weird is that competition authorities hate it. They don't want to be asked to help. And that little quote, and it's understandable why they don't want to be asked to help. They have few resources as it is. Everybody's incredibly busy. If they have to, you know, divert resources to private enforcement cases, it's going to be problematic for them. Especially because that's in principle not remunerated if it's an institutional assistance by the competition authority. But this, from an academic perspective, this idea that national competition authorities don't have to help the court, even if they receive an order from the court, they only have to help it if they consider the assistance to be appropriate. What? That makes no sense. It's not up to an administrative authority to say if it's convenient to obey a court order. You know, if the court orders assistance, they have to comply. And here, this is another one of those issues where there might be a limit to the primacy of EU law, but this is a theoretical discussion. Come on, let's not waste too much time on this, because it's just not reasonable to think that we're going to have, you know, national courts turning to the competition authority and telling them, please help us quantify this damage. Doesn't seem, it can, but it just doesn't seem plausible. They can turn to professors at universities, economists in different universities or in the private field who can help them do this. And their rules for costs provide ways to remunerate that work. So why would they turn to the competition authority? So this is probably not worth too much of our time. Still within quantification. Quantification and distribution and damages for consumer protection is, well, I mean, it's absolutely unheard of so far, and an endless pit of concern for me at least. So all the precedents that we have are, as I've said before in this course, consumers have never really been compensated, except for antitrust infringements, except for that one case with the football shirts in the UK. And so few people were compensated there that it just showed why it wasn't working. And then the UK moved from an opt-in to an opt-out model. Now, under opt-out models, theoretically, there is a very clear way in how you compensate consumers and how you go about quantifying and distributing damages, and I want to go through that quickly. The opt-out model, and of course there are subtle differences between the laws of the UK and Portugal and Netherlands, who now has WOMCA, and so there are certain, Belgium also has a regime now for this. There are subtle differences, but generally, I would say that what tends to happen is you go before the courts, someone is given the right to represent all consumers who were affected by this practice. You know, there might be there are different requisites for who qualifies and how you can determine who is represented. But once the class has been defined, who you are representing, you then go to discuss two things. One, what was the total damage caused to this class? So you're going to calculate a global compensation. And speaking now for the UK and Portugal, which I know better, once you determine that global compensation, the defendant has to pay the global compensation. It's put sort of, let's call it an autonomous fund. It's put in a little bag of autonomous with that global compensation money. The basic idea there is that just because it is difficult to individualize damages doesn't mean that the infringer should get away with it, right? The infringer shouldn't keep the money of the damages just because it's difficult to know exactly how much each specific person was damaged. We can calculate the total damage on a macro level. That's relatively doable. And so you are complying with the principle of compensation because you know that this universe of represented peoples had this level of damages. On a macro level, economists can do that. What is really difficult, with some degree of uncertainty that has to be resolved by the court through estimation, but what is really difficult is the individualization and distribution of damages to specific people. There, the courts will have to use approximations, and they'll have to say, you know, unless it's a market where it's easy to get invoices, but most of them, you know, people can provide invoices of their purchases. But if it's a banana cartel, nobody has receipts of bananas they bought 5 years ago. So the court is going to have to come up with a simplified way of grouping people in classes and saying each Portuguese family, each UK family, on average, purchases these amounts of bananas. If they have, depending on the number of people in the aggregate, they'll be entitled to this amount of compensation, something like that. An approximate way, because if they don't do that, they're infringing the obligation to estimate the damages, and they're also infringing the effectiveness of the right to damages. What happens afterwards is that the court decides, okay, what is the share that each consumer is entitled to? Come get it. Do this. If you do this, you're entitled to get your share. But then the vast majority of people won't come get it because of inertia, because of lack of information, whatever. And whatever is left in the pot of the global compensation that was paid is then surrendered to the state. It might first be used to pay the costs of the promoter of the action, depending on the rules on costs, but it's then surrendered to the state. And it's the state that keeps the leftover money of the global compensation, not the guy who broke the law, right? Not the company who broke the law. And that seems to a perfectly reasonable, fair solution. Maria Jose is saying, in that sense, the proposal of April 2018 was better than the current version, and a shame competition was left aside. She's talking about the proposal of the collective redress directive. Yeah, there is intense lobbying going around. The proposal, well, first of all, it's just a proposal. Let's see how it turns out in the end. But it's complicated. There was more openness to opt out now in the proposal than there was some years ago. But it's still not enough. It's still, you know, business lobbyists, including the American Chamber of Commerce, they're being incredibly successful in lobbying EU legislators to prevent them from saying something which is obvious, which is the only way to get consumer protection is to have this kind of opt-out solution and to have reasonably flexible rules for pursuing these actions in court, subject to control by the court, right? Always subject to control by the court, especially to prevent disproportional remuneration of lawyers and disproportional remuneration of funders, right? So that's the main concern, and that is so easy to avoid. And every system that has these has rules against abuse. But you know, I put there Merrick's v. MasterCard. Merrick's v. MasterCard is being litigated yesterday and today before the Supreme Court in the UK. It's precisely about this, and the very soul of opt-out in the UK is on trial. The bottom line in Merrick's v. MasterCard in this regard comes down to this. The Competition Appeal Tribunal was faced with the first opt-out action representing basically all consumers in the UK, above 18, I think. And it said, well, you know, please, I'm oversimplifying this. Of course, I'm oversimplifying. But it said, the Competition Appeal Tribunal said something like, you have not given us a persuasive evidence. This is done, by the way, in the phase where the court is still deciding whether the case can move forward. They're still deciding on whether to certify the class. So they haven't even started discussing the facts of the case. You know, as representatives of the class. They're still determining if the opt-out action can move forward as an opt-out action. And the court says, you haven't persuaded us that it will be possible in the end to individualize these damages and distribute these claims in a manner that is compatible with the compensation principle. And then it goes to the appeal court, and the appeal court says, well, wait a minute, if you interpret the law like that, you're basically saying there will never be opt-out damages actions to defend consumers, because they did give you some ways of, in a very simplified manner, coming up with distribution of damages for consumers. You have to let them discuss that later on, and not at the level of whether you're deciding whether or not the opt-out action can move forward as such. Because if you're that demanding at that initial stage, what you're saying is you were never going to have opt-out. How can you ever, if somebody bought bananas, how are you ever going to persuade the court at this preliminary stage that you have a way of very precisely identifying that who was affected, so that the costs of these bananas were passed on to the added costs were passed on to the consumers, and how much they were affected? You can't be too demanding there, because otherwise you're saying we can't have opt-out actions, right? And the law clearly says that you can have opt-out actions, that these opt-out actions can result in a global compensation, and that this global compensation might not be distributed to consumers, at least entirely. The law rests on the assumption that at the end, it might not be possible to distribute completely to consumers. And it says that if that happens, it goes to the state. The idea is to take away the money from the infringer, calculate the global damage, take away the money from the infringer, and then if it's not possible to distribute fully or very precisely, you estimate it and you do the best that you can. And so this is what is being discussed now before the Supreme Court in the UK, and the whole of Europe. Well, it's certainly at least the ones with opt-out regimes are holding their breath to see what's happening there. And Maria Jose is pointing out that Maria Jose, who is an expert on collective redress from France, Maria Jose Ozarbo, she's pointing out that this issue has already been discussed in Canada, and the Canadian jurisprudence already provides clear indications of precisely a reasonable solution for certifying classes in opt-out in a way that does allow opt-out to be effective. Of course, the other option for representing consumers are opt-in actions, but opt-in actions, it's just not reasonable for the vast majority of cases. The damage has to be enormous for people to overcome their inertia. And I don't want to go into so many details because we're running out of time, but I want to say this. Opt-in, countries that only allow opt-in, sooner or later, are going to have a referral before the Court of Justice of the European Union, I hope, saying the following. Look, here is an action for damages where each consumer has an expectation of getting like 3, 4, 5 euros damages back. That's millions and millions when you multiply by the number of consumers, but for each consumer, that's nothing. It costs them more in terms of opportunity cost to read the information about the case, come up with a decision if they're affected, and send a letter to be represented, than they have any expectation of getting back, even if they're successful. So if it costs them more to opt in than they might get back, if you only allow opt-in, it means that you are depriving their right to damages from effectiveness. So my dream is that sooner or later, the Court of Justice will get the chance to say, depending on the facts of the case, depending on the amount of the damages and other factors, you might need to create an opt-out solution whereby some people are entitled to represent all consumers. Otherwise, the right to damages of consumers will not be effective. The other thing about quantification is interest. So we've already discussed this. I'm just going to go very quickly over this. So interest, the idea is that you have to achieve full compensation. In order to achieve full compensation, you have to be remunerated for the opportunity cost of the time during which you did not have the capital corresponding to the compensation you're entitled to. There is some margin here for national rules, but what is clear from the case law is that you cannot have rigid national rules. You need to allow for a case-by-case assessment. So the practical implication of that. You can have these these subsidiary legal interest, legal rate of interest. For example, in Portugal, it's 4% of the rate of the civil late interests. If nothing else is specified, is 4%. And you can apply that, the National Court can apply that in principle, but the claimant and the defendant have to be allowed to try to prove that subsidiary rule is unfair, because in the specific case, it leads either to an insufficient or to an excessive compensation. And then it becomes a burden of proof issue. And there is the reference to the paper, to the study coordinated by Professor Giorgio Monti, which not only has an overall look at the EU situation on this and the case law, but it also has national reports. And there you can really see the drastic differences between the member states. But when you're looking at this study, please keep in mind that it was done before, you know, it was done at a time when you didn't have Skanska, you didn't have Cogeco, you didn't have Otis. So it's done at a time when it was not yet obvious that interest was governed by EU law. Let's move on to causality. What is the causality test in EU law for private enforcement of antitrust? We need to have a sufficiently direct link. There has to be adequate causality. Not different from what you find in national laws, in most of our national laws. The key issue, and now we go back to some of the questions that we discussed earlier on in this session, the key issue is the damages have to be reasonably expectable. They have to be foreseeable. Basically, you have a right to be compensated, or you have an obligation to pay those damages if you could reasonably foresee that your anti-competitive behavior caused those damages. You can reasonably foresee that if you have 90% of the market, I'm talking about now about umbrella damages in Con, right, which the court already clarified that it does pass the causality test. Why? Because you can reasonably foresee that if you have 90% of the market between all the cartel members and you raise the prices, microeconomics tells you that you're going to have an impact on the rest of the market, because the rest of the market will have a tendency to also raise the prices, and they don't have enough outcome capacity. It depends on the characteristics of the product and of each supplier. But if they don't have the capacity to increase their output tremendously, this means that there will be umbrella effects on the market, and you're going to see your cartel affecting the prices charged to the clients of other people. That is reasonably expectable, and companies know that that's going to happen, or at least depending on the circumstances of the case, they might know that that is going to happen. It is also reasonably expectable, let's talk about Otis, it is also reasonably expectable that if public authorities were forced by law to give loans with low interest to companies, and those companies bought your products, and those products were more expensive than they had to be, those companies therefore had less capital available, and they had to ask for bigger loans, right? I mean, again, I'm simplifying this, please. This is, I'm just trying to fit this into a few seconds. But it is reasonably expectable, therefore, according to the court, that these public authorities would have been forced to give higher loans with those low interests, and that means that they wouldn't have been able to apply that capital in other ways. And so this causes them damage. This is reasonably expectable. There is a sufficient causal link between the behavior and the infringement. And of course, in indirect customers, you have to apply the same logic, right? The directive says that indirect customers or indirect purchasers, it can go up or can go down, can also have a right to compensation under the directive and under EU law, under Article 101 and 102. Even without the directive, this would be the case. There is still no case law of the court specifically on causality for indirect customers, but through an ad majority's reasoning taken from Con, we know that this is true, because Con is not even indirect customers, it's customers who aren't even yours. So, you know, that's even more out there. So clearly something less will also be caught by by the causality test. It's a very simple idea to understand. If you look at the rule and the directive, if you sell, you're making you're selling a refrigerated drink, and you sell it to a distributor, the distributor sells it to the consumer, it is expectable that if you have increased the prices of that price to the distributors already have very, very small profit margins. Usually if you're looking at supermarkets, you're going to be talking about margins of 2 to 3%. And therefore they can't absorb the increased cost of your product. They're going to pass on the increased cost to clients. Certainly they're going to pass on some of the increased cost, if not all. There is a significant difference between EU law and American law here. In the US, you cannot claim indirect damages, right? If you're further down the vertical chain, the traditional case law of the Supreme Court says that you don't have a right to damages. That is bizarre for Europeans, and I think it's becoming bizarre for Americans as well. And if you're interested in that, look at the way that the Supreme Court got away with softening this approach in the recent Apple case about apps, where it did allow, effectively, it allowed indirect clients to claim damages, and it did so with a softening of the previous case law. This in the Trucks Cartel, let's keep going back to our anchor. In the Trucks Cartel, this issue of indirect customers comes up when you're discussing trucks which were not directly purchased, but which were purchased through leasing or were not even purchased. When I say purchased for leasing, you know how it works. You pay a monthly amount, and then at the end, you pay the residual, and the truck becomes your property, for example. Or renting. They might not even own the truck at the end, and they were paying an amount. Now, the argument there is the same as any passing on of damages along the vertical chain. If companies who specialize in doing leasing and renting, they're going to calculate how much you have to pay every month depending on the original price of the truck. If the truck costs more, they're not going to absorb the higher price. They're going to divide that higher price among the months that you're going to be remunerating them. So the person who is renting the truck is going to be paying for a higher cost. Let's talk about presumptions. I told you that presumptions are going to be the real complicated issue in temporal succession discussions. So what are the presumptions that we have in the directive? They're causality presumptions. Some people think one of them is a quantum presumption, but it's not. It's a causality presumption. There is a presumption that cartels cause damages. You find that in Article 17.2. This presumption is useful, but not as useful as people think. So all you know is that a cartel causes damage. Okay, but you still have to quantify the damages. And if you have to quantify the damages, you have to prove that there were damages. So that doesn't really help you. Where it might help you is if the court is faced with a situation where it was just so difficult to quantify damages. It's absolutely impossible. There's no way to prove that there were damages, much less to quantify them. But the court has before it a presumption that there were damages, and then the court is legally required to say that there were damages and to estimate how much they were. I'm not sure that this will actually happen in practice, but if it does, it's going to be a big challenge to judges how to deal with this. It's not a presumption that cartels cause a certain percentage of surcharge. However, some countries, Hungary and Latvia, Hungary already did this, and Latvia did this in the course of the transposition of the directive. They put in their national transposition laws, they went beyond the directive, and they put in their laws that there is a presumption that cartels cause 10% surcharge. There is a study for the European Commission done by economists that went over many cartels and their impacts, and they say, on average, the cartels that we looked at caused a 20% surcharge. So when Hungary and Latvia are saying 10%, they're already being conservative based on that study. And there is an argument to be made, therefore, that if it is excessively difficult to quantify the damage and you have to estimate it, that courts can and maybe should fall back on these economic studies about, on average, how much do cartels cause in terms of surcharge. how much damage. And so the courts could fall back on this study by the European Commission and saying, well, I have to guarantee effectiveness. I have to estimate, and these economic studies say on average they cause 20% damage. I might want to be a little bit more conservative there, just in case, but I'm going to fall back on these economic studies and say, presumption of damage. The other guys can prove that it's not the case, that for whatever reason, in this case, the conditions were not met and that presumption should be set aside. But I think that effectiveness might lead some courts to think that there should be a presumption here, even if the law does not set out that presumption, that there could be a judicial presumption created here, or arrive at the same result without creating a presumption. And then you have Directive Article 14.2, which is a presumption of passing on. Certain requirements are met, which is basically, if you bought a product from a product that was affected by the cartel, and that cartel resulted in an overcharge or a surcharge for the direct purchaser, there is now a presumption in the law that that damage was passed on to you, at least in part, right? And notice that the presumption, the way that it's written, it doesn't say in part or in full. It just says there is a passing on to the indirect purchaser. It doesn't say in part or in full. So that's another issue for debate. On the other hand, the opposite does not exist. There is a presumption of passing on for the claimant if the claimant shows that these requisites are met. And again, maybe before the damages directive, the principle of effectiveness might require you to either apply the same presumption or something close to it, where you reduce the evidentiary burden. But there is no corresponding presumption for defendants, whereby they have the right to invoke passing on, but there is no presumption of passing on. They have to prove that the damage was passing on. And that is very difficult. In Spain, some courts have been particularly restrictive in the way they look at this. So the manufacturers go before the court and they say, there was no damage whatsoever, we owe them nothing. But if there was damage, they passed it on to their customers, right? And in order to prove that they passed it on to their customers, they ask for access to documents in possession of the claimant. And some courts in Spain have replied, no, we're not going to give you the access to those documents. It's disproportional because you have told the court that there is no damage. So if you think there is no damage, you think that there is nothing that they could have passed on. I mean, it makes some sense. I understand where the court is coming from, but this is a real dilemma. If courts are going to do this, this is a real dilemma for claimants. If, let's put it this way. I mean, and most of the times defendants are doing this because they want to, they just want to try their luck. Maybe maybe the court will agree with them that there is no damage. But let's imagine a hypothetical scenario where the defendant is absolutely convinced that it is a fact that there were no damages, and it goes to court and it argues that. But it has to be careful. It has to think, well, maybe the court is going to disagree with me, and the court will be wrong. But if it does, there's nothing I can do. So let me, just in case, ask for access to evidence. If the court doesn't allow that subsidiary argument, that's complicated. That might be an issue for the rights of the defense. And thankfully, I've managed to end the presentation with 2 minutes to spare. And I have a question here from Grigoris, and I invite you to submit other questions if you have them now. Grigoris asks, in your opinion, is there any possibility in this uniform EU causation test for excluding any categories of claimants, however remote? Example, even harm to employees' shareholders is foreseeable, which many legal systems would tend to exclude from claiming damages. Yeah. You're absolutely right. So I don't know about the employees. I don't know about the employees being foreseeable. It really depends on the case. I mean, if you drive a company to bankruptcy, damages to employees is foreseeable, but that's not really what happens. So I'm not sure if the damage to employees will be foreseeable. And even if you drive it might not be obvious that you would drive a company to bankruptcy. So That might be a little too remote. Damage to shareholder, that is a really interesting question to consider. Yeah, might shareholders come and claim that throughout these years, the profits of the company would have been higher had it not been for the anti-competitive practice? They had a certain share of those profits, and therefore their share was lower than it should have been. Probably. That is certainly foreseeable. Why not? You know, the way I would get around that, however, is to say this: the EU law prohibits overcompensation, and if you have a claim by shareholder, you have two problems. One, you have to make sure that you're not going to give the same money to the undertaking and to its shareholders, right? So you would have to avoid an overlap of an overcompensation because of the overlap of the damages that you're giving to both. That's the first problem. The second problem is I'm not sure that shareholders, unless they are no longer shareholders of the company, I'm not sure that the shareholders have a case there, because if they are still shareholders of that company, they're going to receive their share of the profits through the compensation that the company is now going to get, right, in principle, unless the company makes investments. But then it's a problem of the company and how, and then you have also a causality issue, because if the company had that money back then, maybe it would also have made investments back then, maybe they wouldn't have made. So yeah, very complicated causality issues when it comes to shareholders, and I'm not sure it would pass the test. They'll have to look at it in the specific circumstances of the case, as always. Any other questions? Okay. In that case, I would like to thank everyone for attending this session, and I will see you back here tomorrow for our last day. Thank you very much.